Hello and welcome to a new episode of Legal Wrangle on corporate laws. In this episode, we bring you 6 important cases relating to competition issues, levy of stamp duty, definition of wage, insider trading, and winding up of proceedings initiated by lender against guarantor. Our first case deals with the breach of confidence due to unwarranted delays in the completion of the project by one construction company. The prime issue was whether the construction company has indulged in an unfair trade practices when housing project is not completed within the stipulated time and no status of completion of the work has been intimated to allottee of the flat. Let's go to Shweta for the facts of the case.
Dr. Manjeet Kaur Monga was a allottee of the flat booked by her mother-in-law in the building proposed to be constructed by Suneja Towers Private Limited. She paid part of the payment for a flat, but even after making several requests, was not informed about the progress of construction and expected date of completion of a project. Hence, she stopped making further payment. As a result of that, builders cancelled the allotment of a flat. The complainant filed a complaint under Section 36 of the MRTP Act, which, due to coming into existence of the Competition Act 2002, was transferred to the tribunal.
The tribunal held that construction company was guilty of unfair trade practice as it issued brochure with the promise to complete project within 3 years. But neither it completed the project on time, nor it informed the allottees about the actual work progress. For the harassment caused to Dr. Mrs. Manjeet Kaur Monga, it was directed to pay compounding interest at the rate 15% per annum and refund the actual amount received. The second case relates to the cartel, price fixing and collusive bidding. The key issue was whether, in absence of any direct evidence of the existence of an agreement or cartel, is it appropriate to infer the existence of an agreement on the basis of circumstantial evidences? Shweta has the details of the case.
The Commission took suo motu cognizance against 13 manufacturers of CN container for allegation of suspected cartelization in 3 factories on the basis of a report of the CAG. DG conducted investigation. DG noted that even though the opposite parties were located at different places, some of them quoted identical prices in response to few tenders, while others had refrained from participating in the tender process.
The Commission confirmed the findings of the DG and held that in the present case, price parallelism coupled with peculiar market conditions like few enterprises with same owners, stringently standardized products, predictable demand, etc. unequivocally establishes that the conduct of opposite parties of quoting identical, similar price bids was only due to collusive tactics adopted by them in violation of Section 3.1 read with Section 3.3a and Section 3.3d of the Competition Act 2002. The Commission also imposed a penalty on the opposite parties at the rate 3% of their turnover starting from financial year 2010-11 based on the financial statements filed by them. Our third case clarifies a very crucial dispute with respect of levy of stamp duty. Dispute was whether the stamp duty is payable on transactions or on instruments. Here are the facts.
The respondent, Coastal Gujarat Power Limited, arranged fund for its project from 13 financial institutions. It formed a consortium as a trust and executed a security trustee agreement. It also executed a single deed of mortgage for providing security to said 13 distinct financial institutions. It paid stamp duty on the value of the instrument and the deed was registered. Revenue objected to the same on the ground that the respondent was liable to pay higher amount of duty on distinct loan transactions and not merely on a single deed of mortgage. Matter on appeal reached to the Supreme Court.
The Supreme Court held that the respondent was liable to pay deficit stamp duty as several matters were contained in one instrument. Respondent had entered into a separate loan agreements with 13 financial institutions. Had the respondent entered into a separate mortgage deed also, then it had to pay stamp duty accordingly on every separate deed. Hence, by executing single deed of the mortgage, respondent is not allowed to evade stamp duty. The Supreme Court also ordered for the payment of interest as directed by the revenue authorities. The fourth case brings a vital aspect whether remuneration paid by the employer to the employee for the work done during paid holidays constitute wages and whether milk allowance would become a part of wages if there is nothing on record to show that it is a special expense incurred in respect of an employee considering the nature of his employment. Shweta brings the facts of the case.
The petitioner company received a letter from ESI Corporation seeking information regarding holiday wages and overtime payment. Petitioner replied that the holiday work was not in addition to the 48-hour work in a week and workman is paid double the wage for working on a paid holiday. ESI Corporation held that remuneration paid to the workers for working on a paid holiday could not be termed as wages. Moreover, milk allowance paid to the workmen to cope with the harsh nature of their employment would not be termed as wage. But according to the petitioner, the extra remuneration paid to the workmen for working on holidays could not be termed as overtime, as overtime was a completely different concept. It should be more appropriately classified as a component of wage. Hence, challenging the said letter, petitioner filed writ petition in the High Court.
The High Court held that the wages that were being paid for work done by the workmen on paid holidays would not be treated as overtime, as in numerous judgments this word overtime is defined very narrowly. The word wage is defined liberally since Employees State Insurance Act 1948 is a piece of beneficent legislation. The High Court further held that milk allowances paid to the workmen was a part of wages as the nature of the work carried out by the workmen for petitioner was not of such nature which demands a milk supplement to maintain the health of the employees. The next case deals with the indulgence in insider trading in violation of SEBI Act rules and regulations. The main issue was whether dealing in securities under Regulation 2D of the PIT regulations include pledging of shares and whether having possession of unpublished price-sensitive information, respondents have sold shares of the company at higher prices and made off-market transfers, pledged shares and benefited the cost of the bona fide investors in the market. Let's move to Shweta for the details of the case.
Thanks, Neha. Well, in year 2009, the ex-chairman of Satyam Computer Services Limited before SEBI admitted certain flaws in the working and financial reporting made by the company since January 2001. SEBI carried out investigation, which revealed that directors and few employees of a company were misrepresenting books of accounts. The investigation revealed that since the year 2001 to 2008, various promoter group entities which were in possession of unpublished price-sensitive information had sold shares in the market and made off-market transfers to other entities. In January 2009, when this news of fraud became public, price of shares nosedived drastically. SEBI noted that one promoter group entity, SRSR Holdings Private Limited, was used by the directors of the company to serve as a front to obtain funds through the pledge of shares. SEBI issued show cause notices to all the concerned persons. Considering their replies, written submissions and material available on record, SEBI passed the order.
SEBI held that the word dealing in securities as defined under Regulation 2D of the PIT regulations include all commercial dealings including pledge of shares, as the mode of transfer is immaterial for the dealings to fall within the ambit of this definition. The SEBI further held that the parties who were insiders and indulged in insider trading to disgorge the amount of undue profit made by them. Respondents were restrained from accessing the securities market and further prohibit them from buying, selling or otherwise dealing in securities directly or indirectly or being associated with securities market in any manner whatsoever for a period of 7 years. Moreover, amount to be disgorged is to be paid along with simple interest at the rate 12% per annum from January 2009 till the date of the payment within 45 days from the date of this order. The last case deals with winding up proceedings initiated by the lender bank against the guarantor company. The issue involved was whether winding up petition under section 434E of the Companies Act 1956 is precluded by mere fact that the lender bank has also filed civil suit for recovery of the debt due from the debtor company for which the respondent company stood as its guarantor. Let's look at the facts of the case.
The petitioner is a foreign bank which entered into a loan facility agreement with Hastia Holdings Limited, which is a wholly owned subsidiary of the respondent company Sujana Universal Limited. The respondent company gave guarantee for this transaction. Hastia Holdings Limited defaulted in repayment of a loan amount. Therefore, the jurisdiction of the commercial court was invoked, and decree was passed by court in England directing the borrower company and the respondent company to repay the principal amount along with interest. For enforcement of this decree, execution petitions were filed in India by the lender bank before the City Civil Court, Hyderabad, for recovery of the decretal amount. Besides, it also sent a statutory notice under section 434 of the Companies Act to the respondent company Sujana Universal Limited and its directors. The respondent company was unable to pay the debts.
The High Court held that lender bank is entitled to invoke the jurisdiction of the company court under section 433E read with section 434(1) of the Companies Act, as lender can proceed simultaneously against the borrower and the surety or against either of them. While section 433E of the Companies Act also refers to the inability of the company sought to be wound up to pay its debts, the legal fiction in section 434(1)(a) thereof equates neglect to pay with inability to pay. Proceedings for winding up under section 433 of the Companies Act cannot be equated to the suits, or for that matter suits for recovery of money. Well, this brings us to the end of the second episode of Legal Wrangle on corporate laws.